Hey everyone. So this month, because it's March Madness, we're doing um, a theme of things that make us the maddest about workers' comp. And to help me, I have Mad herself, Melissa Day, here with us. And we're going to be going through the top 10 things that we're mad about.
You dated yourself, by the way, with that slide.
I know, right? Still younger, still younger. So the first thing, number 10, coming in at number 10, reduced earnings and self-employment income. So the situation, you got a claimant who owns a business, tends to include a multitude of expenses to lower the amount of the gross earnings used to calculate reduced earnings. So the law on that is a claimant's eligible for reduced earnings awards when he or she returns to work at a lower wage rate, and that lowered wage rate is determined to be caused, at least in part, by the causally related disability. So how do you calculate reduced earnings award? It's essentially 2/3 the difference between the claimant's average weekly wage and the claimant's wage after returning to employment. And in calculating self-employment earnings, the boards adopted the approach in Young v. Utica Mutual Insurance Co., which is basically that in determining the sole proprietor's earnings, a business owner's earnings, you essentially take the necessary and mandated items, but you exclude from the deduction any optional or elective items. So when you're determining when you're determining gross earnings, you would exclude from that optional or elective items, and that would increase the amount of gross earnings they have. So actual earnings from self-employment income, as I stated, is based on the claimant's gross earnings, reduced by all necessary mandatory expenses, but not by optional elective expenses. So expenses are necessary or mandatory if they're essential to the operation of business. So that's kind of really what is important there, if it's essential to the operation of the business. Optional or elective expenses, although they may qualify as tax deductions, are not essential to business operations. Something that enhances or promotes the business or contributes to its continuance, that's not seen as necessary or mandatory. Oh, wrong direction.
I literally just reviewed an appeal for our office on this issue with somebody renting rental space for a fitness class.
Yeah, it most of what I found is essentially it concludes that it depends. So some examples of mandatory expenses: professional fees, telephone services, equipment, utilities, security systems, for massage therapists, supplies like oils, waxes, creams. So it really depends on the nature of the business to determine what is essential and mandatory. And I just thought it would be very interesting to see what sanitation costs, whether that would be included because of COVID, if they're considered mandatory or optional.
Probably because they were mandated, I would think that they would be considered mandatory.
There would be some hefty cleaning bills.
Yeah, we did enjoy some reduced expenses, obviously, because of COVID. Like, we didn't have to spend as much on utilities, but we made up for it in other areas.
Yeah. So some optional expenses: advertising, office expenses, repairs, maintenance, bank charges, uniform, laundries, outside services, charitable donations. Of course, a lot of companies or, like, a lot of business owners might try to use charitable donations to lower their gross earnings. Legal or professional services, though, I tend to think were more necessary. Pension, profit sharing plans, and see, here's what you're talking about: rent and lease of other business properties, except where the rent or leases of the building that houses the business itself. That's from Matter of Sam Dells Dodge. Subscriptions, unless the subscription is necessary to the business itself. For example, where a claimant owns a vehicle repair shop and maintains a subscription for online parts catalog system that is necessary to perform repairs. That was seen as a mandatory expense. Depreciation, meals, entertainment, those are all things that may promote or help the business, but generally speaking, are optional expenses. But as I said, everything sort of ends in, it actually depends, because the board has found meal expenses necessary for long distance truck drivers, but not necessary for a dog groomer who operated her business in the town where she resided. Basically, if you can go home to eat, go home to eat. So number 9, denial of development of the record because there's no contrary IME report. This actually just happened to me yesterday. It's so frustrating. So
Yeah, this one makes me pretty mad.
yeah. So example, the claimant has evidence of, for example, total disability that's clearly incredible. You want to depose the doctors without getting an IME, the judge denies the request because there's no contrary IME. Or the claimant's medical evidence indicates a possible new accident. You file C8.1Bs, request that the judge finds them in favor of the carrier, or alternatively, you request testimony. Judge denies the request because there's no contrary IME. I tend to think this is crap because if you look on the face of these reports, they're incredible, or they are at least prima facie evidence of a new accident. So that should be reason enough to delve further into these, into the record, and that should be sufficient to warrant testimony. If you can bring up something in the report that contradicts the conclusion of a total disability, you can bring up something in the report that contradicts causal relationship, you should just automatically be allowed to cross-examine these providers. But without a contrary IME, judge says no.
And I wonder if you could, in that situation, argue that the presumptions in Section 21, which say that, the contents of medical reports are prima facie medical evidence or prima facie of the facts contained therein. Well, if it's suggestive of a new accident, then it's prima facie evidence, it's presumption that it's, that it is what it says it is, and that unless there's substantial evidence to overcome that statement in the medical report, then that governs the file.
I would tend to think so. I mean, most people think that presumptions always work for the claimant, but they can work against the claimant too.
Right.
So I would definitely use the presumption there too. And in fact, I argued that yesterday in a memo of law as well.
Good. Well, it'll be interesting to see how that works out.
Yeah. So here's some things to keep in mind. One, the claimant bears the burden of establishing a causal relationship between employment and disability by an offer of competent medical evidence. That's the big thing that we cite time and time again. And then the other thing is that Rule 310C provides that the carrier may cross-examine any attending physician whose report is on file, and that an adjournment shall be, not may be, it shall be granted for that purpose. So where you have instances where the claimant's not meeting the burden of proof and you want to cross-examine that provider, Rule 300.10C should permit you to do that. So again, back to our example.
Denials of development of the record where we request cross-examination of an attending physician are very susceptible, very vulnerable to being reversed on appeal. I mean, that is a good issue to bring up.
Yeah. I think in those cases, you're just essentially making an argument for the board anyway.
True, because there are judges that don't care.
Yeah, the judge will never do it, but you request it for the board so that you made the request timely.
And it's actually always smart to request development of the record of an attending physician if a judge is making an adverse ruling against you, because it does give you a very viable issue that you could pursue to the board panel.
Interestingly, now that I think about it, you should make that request the very first thing you do, because if you're arguing against C8.1Bs and the judge says, no, you don't have a contrary IME, I'm finding them in favor of the provider, and then you request cross-examination, the board may find that you didn't raise it timely because the judge has already made his decision. You have to raise it before the judge makes his decision to request development of the record.
So Brian Prince and I recently received an adverse decision from the appellate division that we are pursuing an appeal to the Court of Appeals. So we have a motion pending at the Court of Appeals on this issue, where the attending physician found total disability. We did not challenge that total disability, and in fact, payments were made at the total rate until the first hearing, at which time we requested cross-examination of the doctor on the issue of degree of disability, and it was denied. And the board and the third department found that our request was untimely. So really what the board is saying, as affirmed by the third department, is that you have to challenge the degree of disability at the earliest possible time. So that timeliness argument is it's important that you pointed that out, Alexis, because that is the one vulnerability that we might have in requesting cross-examination, is if the board and then ultimately an appellate court determines that our request wasn't timely.
Yeah, timeliness, you gotta raise it at the first available opportunity. So there's case law on this. The failure of the carrier to submit a consultant report is not fatal to the right to cross-examine. The only limitation on the right is where the request is not timely made, or there's another one hanging out there where there's no viable medical controversy. Now, some judges will say there's no viable medical controversy because there's no contrary IME. That's not true. You can raise a viable medical controversy solely by arguing against causal relationship. If there's something in the report that makes you think it's not causally related, or for example, if you have an ISO report that indicates another injury, or the claimant had another injury, you yourself can raise that viable medical controversy. It doesn't have to be the medical report raising it. So if there's a basis to dispute causal relationship, that's the basis for your viable medical controversy. Or if there's a basis to dispute the degree of disability, there's your viable medical controversy. It doesn't have to be an IME report. So for example, with degree of disability, you should consult the guidelines to demonstrate that the report on its face doesn't meet the criteria for a total disability. Therefore, there is a medical controversy and cross-examination should be granted.
I find a lot of times that PT, participation in PT can give me the fodder that I need in order to argue that the person's not totally disabled.
Yeah, if you can do PT exercises, you should be able to do something.
And the physical therapist is, going to demonstrate the improvements that the individual is making, because otherwise, why would you continue doing PT?
Yeah, they tend to hang themselves with that by always saying that the claimant's improving from PT to more physical therapy.
Yeah.
And then you're like, well, if they're improving so much, then they're not totally disabled.
And you don't need 12 more sessions.
Exactly. So the example where the medical evidence indicates a possible new accident, you file C8.1Bs. In those situations, defense counsel should argue that the claimant has the burden of proving causal relationship. The face of the report raises a question as to whether that burden has been met. Therefore, there is a viable medical controversy and further development is warranted, if not an outright finding in favor of the carrier. Clocking in at number 8. This big one, unfamiliarity with Section 21A requirements. So the situation is pretty simple, where you just wish to make payments without prejudice under Section 21A, but the carrier inadvertently botches the 21A procedures. the board deems liability admitted and the carrier loses the right to controvert the claim where there was a legitimate basis for doing so. That's really frustrating to everyone involved on the defense side. It's frustrating to you guys. It's frustrating to us because we want to come out both guns blazing. And something as simple as 21A can prevent us from doing that.
And I would submit that there is no statutory authority or regulatory authority for the board to take that position.
So, yeah, this comes from the board's subject number. We know that the board issues subject numbers sometimes, and we don't always agree with them. But this board subject number 046 696 notes that 21A allows an employer or insurance carrier to pay lost wage and medical benefits for 1 year, up to 1 year, without admitting liability for the claims and without prejudice to its right to controvert the claim. But note, it can't be used on medical only claims and it can't be used on death claims. Indemnity payments must be made to the claimant. So at any time during that 1 year period, you can provide notice that you're ceasing temporary payments and you can then controvert the claim by following the proper process if the investigation reveals that it should not be liable. So 21A1 is the basis for that. 21A3 provides the mechanism for suspension of benefits. You may stop payments and for indemnity and medical benefits if it delivers notice of termination to the employee within 5 days after the last payment, and then you retain all rights, defenses, obligations without regard for the temporary payments. But the failure to provide notice of termination shall be deemed as an admission of liability. And the notice of temporary payment of compensation will be converted to a notice of compensation payable. So, like I said, you got to provide notice. Trust the process. Now, this is my boy Joel Embiid, big Sixers fan. So his nickname is the process, and the Sixers went through a period. Trust the process, and that's what I want you guys to do here because the board has very helpfully provided the exact process you have to follow for to end your 21A status and properly controvert the claim.
Yeah, it really couldn't be more confusing because if you have a medical only that becomes an indemnity and you want to be able to make your payments without prejudice under 21A, you've already filed a FROI, which indicates with that W with liability. So then people think like, oh, I'm screwed. I can't do anything about it. I've already bought the claim.
Yeah. So as you mentioned, there are the W's and L's. So you have to indicate whether benefits, when you first make payments, whether benefits are being paid with liability, that's an L, or whether the claim is accepted or paid without liability, which is a W. So whenever the first indemnity payment is being made, you have to indicate on the FROI or SROI that it's being made with an L or with a W. And when it's with a W, that puts the claim in 21A status, and no further notice will be sent by the board. So these are the types of FROIs and TROIs that require W or L designations. Basically all of the initial payment TROIs, the SROI IP, the SROI EP, PY, and AP. The PD, the partial disability, does not. The
No,
SA, the subannual.
PD is not partial disability, it's partial denial. Yeah.
Partial denial. Did I say disability? Partial denial. Partial denial does not. The SROI SA, the subannual, does not. And the SROI 04 denial does not because it's very clearly, obviously, you're controverting the claim with the 04.
What is the asterisk for on the EP, PY, and AP? Oh, sorry.
I don't know.
This chart is taken from the board's guidance page, right?
Website, yeah.
Okay.
So again, continuing on. So when you controvert the case, you want to controvert the case, you file the notice that you're terminating benefits, the Shroy SJ. Okay, so you file the Shroy SJ before filing the Shroy 04 to satisfy the notice requirement under 21A3. That's one way of ending 25A status by controverting the claim. You can also end it by accepting the case, filing a Shroy or Shroy with an L code, or by simply allowing a year to pass. That'll be converted to, you then file a Shroy 02 with the L designation that'll be converted to an accepted claim status. But you can inadvertently lose your 21A status by filing C8.1Bs, objecting to treatment on the basis of causal relationship, or that the claim has been controverted and there's no Shroy or Shroy 04 in the case. Again, as I noted, you have to file the Shroy SJ first, then the Shroy 04. And you can't fail to continue making payments. If you stop making payments consistent with the claimant's treating provider's medical reports, if you reduce those payments based on an IME, you may lose your right to controvert the claim and the case may be established. So some examples, in matter of NYSARC, MSO, Inc., carrier filed a Shroy IP, put a W code in there. Thereafter, they filed the Shroy SJ, indicating it was suspending benefits due to the issue of causal relationship. You would think they'd be safe, but they failed to follow up with the Shroy 04. The board upheld establishment of the claim, pointing out that one of the ways of ending 21A status is to controvert the claim, and that there's a proper process for doing that, to file the Shroy SJ before filing the Shroy 04. And the failure to properly follow this procedure, the carrier ended its 21A status, and the judge was perfectly within his rights to establish the claim without accepting the claim pursuant to its 21A status. And everyone cried. Number 7, claimants who try to use the presumption of compensability in place of actual evidence. This is frustrating because it's one of those buzzwords that claimants toss about that like judges fall for every time without regard for what it actually means. So it's a pretty simple situation. Claimant raises a consequential injury, or claimant raises an initial injury, whatever. They argue that the presumption of compensability hasn't been rebutted and the injury should be established. The actual presumption states that there are 5 of them. The claim comes within the provision of this chapter, that notice was given, that the injury wasn't caused by the willful intent of the employee to injure himself or another, that the injury wasn't the result solely of intoxication. And the big one is that the contents of the medical reports introduced into evidence constitute prima facie evidence of the facts as to the matter contained therein. So if a report says that the claimant was injured at work, it's prima facie evidence that the claimant was injured at work. But you can't use it in place of actual evidence. For consequential injuries, the judge in a matter of HRA, Department of Social, the board found that the claimant raised consequential injuries, but the treating provider merely relied upon the claimant's statements made by the claimant, which conflicted with her testimony and did not rise beyond general expressions of possibility and disallowed the claim. The claimant appealed, arguing presumption of compensability, but the board affirmed the finding, stating that while the claimant can argue the presumptions regarding compensability for notice and prima facie medical evidence, those presumptions don't completely relieve the claimant of the burden of demonstrating the fundamental elements of the claim. The board noted that mere expressions of possibility does not satisfy the claimant's burden of proof. So one thing I wanted you guys to note is that while the presumption may be used for PFME as noted above, the claimant still has the burden. In cases where the medical evidence is sufficient for PFME, but insufficient to establish the claim, you should consider waiving the testimony of the treating provider, which will only provide them with the basis to shore up their report. So it's risky, of course. You should discuss with your counsel kind of the risk involved there and decide if you want to take that. But in many cases, the board is more likely to overturn establishment of the claim than the judge is to disallow the claim. You may be arguing for the record for the benefit of the board on appeal. But if, like I said, if the report is sufficient for PFME but not sufficient to establish the claim, you should consider waiving the provider's testimony and waiving an IME.
It's good advice.
You know, and I would just add there that the courts have even gone so far as to say the presumptions don't apply on consequential issues in the first instance anyway. So that analysis was pretty generous to the claimant on a matter of law.
Yeah, I take the position that they don't apply to consequential injuries because all of the 5 presumptions kind of apply to claims in the first instance. Notice that the injury wasn't occasioned by the willful intent of another. Those are all sort of things that apply to initial injuries.
Yeah, that's a to take.
Clocking in at number 6, not including enough information on the C8.1b to help us defend it, and not listing every applicable basis for the objection on the C8.1b. This is where you guys have to help us out. We get to a hearing, and for example, if we object to an untimely bill, but it doesn't indicate the date of receipt of the bill, the judges typically ask us, when was it received? And if there's no information in the file or on the C8.1b, we can just say the only thing we have to go by is the date it was filed. And sometimes that's not enough. Or if the bill argues that the medical report for treatment wasn't timely filed or is legally defective, but it doesn't indicate why the report is legally defective, sometimes a little information there would be helpful for us and for the judge to determine whether the bill should be found in favor of the carrier or the provider. Or if the claim is controverted, this is a big one. If the claim is controverted and the only objection indicates that the claim is denied, but doesn't mention any other bases for objecting to the bill, if the claim later gets established, those bills are going to be found in favor of the provider, despite the fact that they may be untimely or outside of the guidelines. You have to put every basis that could apply all on the C8.1b. All those check boxes, you can check multiple ones off. So if the claim is controverted, you should still be looking for the fact that a bill may be untimely, no prior authorization. You should still be looking for whether or not the report is legally defective, whether or not it complies with the guidelines, and you should put them all on the C8.1b so that if the claim is established, you can still maintain those other bases for denial of the bill. So one of the examples for the law 325-1.25C1 states that, for example, treatment or services after December 1st, 2010, you have to object within 45 days on the form prescribed by the board for that purpose, the C8.1b. And 325-1.25C6 defines legal objections, and it includes, but is not limited to, objections that the treatment was not causally related to the compensable injury and that the medical report was not timely filed or was legally defective. So in this example here, this 2018 case, the carrier filed objections to bill for treatment, arguing causal relationship, and the claim was later amended to include these conditions. The C8.1bs were found for the provider. The carrier appealed, arguing that the providers were not coded to treat workers' compensation patients, that the bills had no medical reports attached, and that the licensed social worker was not properly supervised by a coded provider. The board said none of those bases were indicated on the original C8.1b, so they upheld the finding for the provider.
I think we could move on then.
Yep.
You're doing pretty well on time. By the way, I think that this PowerPoint is fantastic and a wonderful resource. So if anybody would like a copy of Alexis's PowerPoint, please feel free to email the hearings at madwcdefense.com or Alexis at ahatten, Hatten, at madwcdefense.com, and we'll be happy to get you a copy of it.
Yeah, we're about halfway through. So number 5, fishing for IME preclusion. So the situation, you're in a deposition, right? And before you even get to the substance of the matter, the claimant's attorney spends the first several minutes grilling the doctor on things about dates and whether they signed it, about the IME3, about our cover letter, whether they have it with them, fishing for any answer that could support their request to preclude the IME. Giant waste of time, in my opinion. So the law, 137, 1A, copy of the report has to be submitted same day, same manner to all parties. We all know that. 137, 1B, any copies of request for information, the practitioner shall submit a copy of the request for information to the board within 10 days of receipt. And then 300.2 B12 states that a report of an examination that does not substantially comply with those requirements shall not be admissible as evidence for any purpose described in 300.2 B4, which is things like causal relationship, permanency, degree of disability, need for treatment, things like that. And then there's rule 300.2 D3, documents that are provided to the IME examiner has to be part of the board file. If it's not in the board file, it should be submitted to the board file the same time it's given to the IME examiner or entity. And 302 D4I describes the contents of the IME reports. Basically, description of the examination, all the information received and reviewed, the professional opinion, and importantly, the certification that no one basically influenced the doctor's opinion.
I found a rather remarkable board panel decision where the carrier provided their IME doctor with surveillance evidence for the IME and did not provide the surveillance evidence or reports to the board file.
Oh, that's interesting because they're not required to provide it to the other side normally.
Right, but you can see how the regulation is at odds with the procedure for disclosure of surveillance. And I've always, the more conservative approach would be like, okay, if we're going to pull the trigger and we're going to give the IME or the surveillance to our IME doctor, then we need to disclose it now and put it in the board file. Well, interestingly, the board found on a case where there was an argument for preclusion of the IME because they'd been given the surveillance and that was not in the board file. The board found that the carrier was not obliged to turn over the surveillance evidence, even though it was provided to the IME doctor, because of the rules on disclosure of surveillance evidence.
Wow.
I was pretty blown away by it.
That's unexpected. So basically, what you need to know here is that an IME3 is only necessary where the request for information involves substantive communication with the IME examiner. And the other thing is that the IME examiner who provides an IME examiner in this case, an IME examiner provided an IME addendum report, submitted an IME3 that did not provide a date and was not signed. But the board panel stated that the form substantially complied. So what you're looking for is substantial compliance with 137, and that no prejudice was caused to the claimant by the doctor's omissions. That's important because we frequently see IME3s that may be missing a date here or there, or a signature. And this case indicates that there was no prejudice caused to the claimant, and the IME3 otherwise complied. So one thing I did note, though, because this actually happened to me maybe 2 weeks ago, you should carefully check all the documents surrounding the date of the IME to make sure the IME3 hasn't actually been mislabeled. As I've seen them labeled as a correspondence. I've seen them attached to IME4s where they're not separately labeled. So actually make sure that the document they're saying has not been provided is actually in the board file.
I like to always challenge an argument, a preclusion argument too, with timeliness, a timeliness argument. The claimant has to raise it at the first possible instance. And so if for example, if like the claimant's questioning our IME doctor about, phishing, like you were saying at the beginning of your number 5, I would argue that the time for the claimant to have challenged IME preclusion was before we set the doctor down.
It's a good point. If they didn't raise it then, if they proceeded with the deposition, then arguably it's waived.
Yep, I've actually argued that and won it in front of a judge, Lawler of all people.
Really? Lawler?
Yep.
Shocker.
Yeah.
Number 4, IMEs disguised as treating providers. This drives us up a wall. The situation is you see the claimant sees a provider once or twice. The provider doesn't render any treatment recommendations. But for some reason, they direct the claimant to follow up in 6 weeks, 8 weeks, however many weeks. And then on the next visit, the provider provides a permanency report. It happens a lot. And one doctor in particular is a frequent flyer when it comes to this issue. So the law, what's a treating provider? That seems simple enough, a provider who treats the claimant, but it's the provider or practitioner who has primary responsibility for treating the claimant for the injury or illness for which the claimant is being examined. By contrast, an IME, it's an examination performed for the purposes of evaluating the claimant for permanency, degree of disability, my ability to return to work, treatment, disability, any of those things recognized by the board. So a report filed by a physician used by the claimant as a consultant has to comply with the regulations for an IME because the board will recognize it as an IME subject to those requirements. So the case law basically says it doesn't matter whether the claimant or the carrier requests the IME, and IME is an IME. Call a spade a spade. So a physician may be considered an IME if he examines the claimant for the purpose of providing an opinion with respect to diagnosis of a disability or causal relationship, or only for the purpose of providing a scheduled opinion. In such case, the report has to comply with 137 and 300.2, or it will not be admissible as evidence.
And they never do.
Never do. Here's why. 137, remember the 3 things: same manner, same day. They always screw up on that. The ones in red are the ones they screw up the most. Same manner, same day to all parties. They never do that. IME also has to be, the request for information shall be submitted to the board within 10 days of receipt of the request. Anytime the claimant's attorney submits something to the doctor asking for an opinion, if that doesn't appear to the board within 10 days of receipt of the request, that doesn't comply with 137. And the responses shall be submitted within 10 days of submission of the response to the requester. So they fail there too, usually. 300.24i, that basically gives the description of the contents of the report. And what they typically leave out is a list of all the records they reviewed in conjunction with the examination. They typically leave out the signed statement certifying that the report is a full and truthful representation of their opinion and that no one's influenced them. So those are the hot ones that treating providers typically screw up, and you can get the report barred, or not barred, precluded under 137. The big offender, Dr. Hecht. So the board's caught him a number of times. We have like literally a whole body of case law just dealing with Dr. Hecht. My advice would be, if you suspect a doctor is doing this, to look up that doctor's name in Westlaw and see if there's any case law on that doctor doing that, because it is particularly persuasive if you are arguing that this doctor is doing that by pointing to a prior board panel decision that caught him doing that.
I like doing that on schedule loss of use opinions too.
Yeah. So these cases, basically the same, you'll see the same pattern all the time, that 2 visits prior to the scheduled loss of use determination or whatever the IME report is, a couple visits before then, no treatment provided. They'll recommend something that's basically inconsequential, like recommended continued conservative care or home exercises or something like that, but they don't actually provide any treatment. They're not prescribing any medications. Recommendations is basically an unspecified plan for proper care. The board will catch that. In both cases, the reports were precluded for failure to comply with 137 and 300.2. Number 3, late C4 off Ds or no C4 off Ds. So in that situation, the carrier receives a C4 off, files a response indicating the treatment is denied pending an IME. IME very helpfully disputes the need for the treatment, but the carrier fails to follow that up with a final denial of the treatment within 30 days. Very frustrating.
These all friends of yours that you got for these slides?
Yeah, I have angry friends.
It's just your last party, right?
Yeah, basically. So as we know, the law says you got 30 days to respond to a C4 off request, and that if you don't respond within 30 days, it may be deemed authorized. 325-148H2 says if the denial is untimely or does not reference or has an attached conflicting medical report, the chair will deem the request authorized. So in these examples, that's essentially what happened. The provider submitted a C4 off request. The carrier indicated it was getting an IME. The IME did not happen within 30 days. So the board deemed the surgery authorized. In that case, the carrier also failed to send a further, once they did finally get the IME, they failed to send further C4 off D. And at that point, C.81A's had to be filed. It also failed to do that. And the board said the carrier failed in its obligation to timely submit conflicting medical evidence and to issue a final denial and to file the C.1A. You don't have to worry about the C.1A's anymore, but you still got to issue that final denial. So the big note in cases like these, the initial denial pending the IME, the initial denial is not sufficient to deny the request for treatment because it's not submitted with a conflicting medical opinion. It's basically a placeholder denial, right? So you need a final denial with a conflicting medical report, and that would satisfy the board rules. And all those steps must occur within 30 days of the request. So you got to move quickly on those cases. The only exception is where the claimant fails to appear for the IME. Two, defective subpoenas. So in that situation, depots are ordered and the claimant's attorney does not reach out to the doctor's office to get availability dates, but issues 2 subpoenas for 2 different dates, wasting everyone's time, and the subpoenas are mailed to the doctor's office. The doctor fails to appear for either of those dates, and the claimant's attorney requests preclusion. We get this all the time. So what's important to note here is that the board does allow the parties to cross-examine the treating providers, as we know, 300.10C, but if the claimant's attorney wishes to depose the carrier's consultant, they have the obligation to arrange it. And essentially that if they resort to serving a subpoena, the subpoena has to comply with the CPLR. So where we typically get them is failure to comply with the CPLR service. Typically, they mail the subpoena to the doctor, but that's all they do. And if you're going to mail it, you have to do what's called, mail or mail, affix it to the doctor's place of business, and then mail it, or serve it on a person of suitable discretion and age, and then mail it. They don't do that. So we typically will argue that the subpoena is defective and that the doctor's failure to appear does not warrant preclusion of the IME report. And the board has agreed with our stance on that since the claimant attorney failed to demonstrate it complied with the service requirements relative to subpoenas, and there is no other evidence in the board file indicating that the doctor was contacted by any other method to provide testimony, it was improper for the judge to preclude the report. So what's important there is that you can't just resort straight to subpoenas. You actually have to attempt to schedule the deposition first. And then if you're unable to get a hold of the doctor, then you subpoena. So the other thing is, as a practical matter, defense counsel should check the record to see if there's any documentation in the board file noting claimant's attorney's defense or claimant's attorney's efforts to obtain availability dates from the doctor before resorting to subpoena. They typically don't file that stuff with the board. We do. Defense counsel should also check the affidavit of service to see if the doctor was properly served. If not, defense counsel should be arguing that there was no good faith effort to obtain the doctor's availability and that service was improper and that the deposition was therefore waived rather than that the IME report should be precluded. We win on that. I just won on that one, actually.
Finally,
number one. This one is my biggest pet peeve. I don't know why this one in particular, more than any other one, bothers me so much, other than it directly conflicts with the medical evidence in the file a lot. But bringing the CCPs to date, despite the medical evidence, frustrates the crap out of me because the award should follow the medical evidence. We've all been there. The claimant is not produced up-to-date evidence for some time, the judge still brings the award to date. There's a CCP in place at the total rate. Gary gets an IME that finds partial disability. We agree to a rate at the hearing, but we want it as of the IME date. Judge still brings it to date.
I'm going to blow your mind again. I found case law which supported the carrier's unilateral suspension of benefits once the medical evidence of disability expired and was not penalized for it.
What?
I know.
So that makes sense though, because isn't there that I can't remember the name of it, but that recent appellate division case that says a penalty is only due if the claimant's entitled to awards? James will know it.
Yeah, the court or the board found that the carrier was entitled to suspend as of the date that the medical evidence of disability became stale, despite there not being a hearing as required under 300.22.
At that point, they're not entitled to awards.
Right, because, and I can't remember exactly what the rationale was, but it fit within the regulatory framework. So if you ever run across that situation, definitely do the research because you'll be able to find something.
That is mind blowing.
No.
So that just basically says that the provider needs to provide file reports every 90 days. And that the carrier must continue benefits until certain criteria has been met, namely the filing of the RFA2, giving notice that it wants to suspend and stuff like that. Those two provisions are not contradictory. The claimant still has to produce the evidence, and the carrier still has to file the notice but there's a mechanism for how you get that suspension as of the IME date or as of the date the claimant's medical evidence went stale. And this case gives us how to do that. So in this case, there was a period of no up-to-date evidence. The next hearing, the judge brought the awards to date, and at the prior CCP rate, the carrier appealed. The board again noted two important things. There's no presumption of continuing disability. So where the claimant doesn't have that evidence of disability, there's no presumption that disability from the last report continued. And that the claimant has the burden of producing up-to-date medical evidence in order to remain eligible to receive continued wage placement benefits. The board then stated that there is basically nothing in the regulations that prevents the awards from retroactively being reduced. It states that continuing awards are always directed with the understanding that they will be changed at some point in the future based upon the claimant's changing condition, and that while it may be reasonable to assume that the claimant continued with the same disability, that there's no presumption that the claimant failed to meet the burden of producing medical evidence for that period, which is required to remain eligible for awards during that period. Therefore, the board found that the claimant wasn't entitled to awards. But what I want to note, you got to file the RFA-2 requesting to reduce or suspend based on the change in or lack of medical evidence. If you think about the RFA-2 form itself, it has that line where you put in the date of suspension. If the judges were supposed to bring the CCP to date, why would they have that line indicating the date of suspension? The date of suspension would always be the date of the hearing.
Good point.
They don't think about stuff like that. So make sure you timely file the RFA-2 the minute you get the IME, because the filing of the RFA-2 is what gives you that right to that retroactive reduction. And that's all I have. Thank you guys for listening to all the things that make me mad.
I like it. Your Lex talk. That's cool. I thought this was fantastic. Great job.
Thank you. If you'd like to know more about any of these things, feel free to contact me. If you want to tell me what makes you mad, I'm happy to listen to any of you guys.
I like how you're saying that, and then you have my email at the bottom.
Yeah, well, yeah. I will listen to you through Melissa.
A Hatton, HATTEN, at madwcdefense.com. All right. Well, thanks, everybody. I don't know what our topic is next month, but I'm sure it'll be just as scintillating and interesting as today was. And
it's going to be medical issues.
What is that?
We're going to be medical issues and some anatomy and some other causal relationship things. We're going to all learn how to play a doctor on television.
Excellent. That sounds great.
Grey's Anatomy. Awesome.
All right. Well, thanks again, everybody, for your participation and for your attention. And we will see you next month.